Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
My name is Marnie Baizley. I'm one of the lawyers at SpringLaw. I'm joined by my colleague Danille Murray. And as many of you will already know, SpringLaw is a Canadian virtual employment and contracts firm. We focus on helping clients with tech-forward and innovative legal solutions. We've been virtual since the beginning of our firm, since our firm was founded 3 years ago. So feel free to ask us any questions about remote work setups. And we've shared a remote work policy for free for all the employers trying to who've transitioned, and so feel free to reach out or check out our website for that. And if you're new to our firm or the law firm community, welcome. You can ask any questions through the chat function throughout the webinar. We'll leave some time at the end to answer questions. You can download the slides under the handouts tab. This webinar will also be put on our YouTube channel later today. And for more information on our law firm, visit springlaw.ca, where we have a variety of resources, including our award-winning weekly blogs, a link to our monthly newsletter, and information about our new Pivot DIY program for employers, which is specifically tailored to deal with the COVID-19 context, and has all kinds of tools and resources for employers who want to try to go it alone and don't need the bespoke strategic advice that some employers do need and want to invest in a DIY online solution. So feel free to check that out at our website, on our website. Okay, so let's jump in. Danille and I are going to be talking today about, first of all, legal rights for layoffs. So what are the logistics and the laws around layoffs? Then we'll move into recalls and terminations, because we're getting lots of questions from our employer clients about recalls and terminations, given that we're seeing light at the end of the tunnel in this COVID environment. Danille is going to run us through updates on government income and subsidy relief programs. And then we're going to talk about some best practices and strategies to help pivot your workforce as we emerge out of this global pandemic crisis situation. And we're going to, while we're going to give you some more technical aspects of the government relief programs, we're also going to try to fit in some strategy tips that we're helping our employer clients with now. So let's jump in. Okay, so starting with the right to layoff. As many of you will know, the Employment Standards Act in Ontario, or all provincial employment standards acts, speak to layoffs. We're going to focus on Ontario today. If you have employees in other provinces, be sure to check the legislation in the provinces where your employees work. But the Ontario ESA sets out the parameters around the right to layoff. And I'm going to talk about the actual layoff periods in a moment. And the issue with layoffs is, unless an employment contract provides for a layoff, unless there's a layoff provision in the contract or a collective agreement in a unionized context, a court might deem a layoff to be a constructive dismissal, because it constitutes a unilateral altering of a fundamental term of the contract. Apologize for the legalese, but effectively an employer has laid off an employee and they're not paying them, and that's a unilateral change to a fundamental term they're not being paid. So we get into constructive dismissal territory there as we understand constructive dismissal. Now, what we're advising clients is there are a lot of unknowns here because of the crisis situation that many employers have been forced into, and they've simply just had to lay off employees where they might not have layoff provisions in their contract, and taking a wait and see approach to see how courts will approach it. And our advice has been, if you follow the ESA provisions in the ESA perfectly to a T, that's your best chance of having a court say, look, this is unique circumstances, and we're not in constructive dismissal territory in this situation, and employers handled in a reasonable manner. So that's our advice, but there's a big question mark in terms of how courts are going to handle these kinds of disputes that we're anticipating, and frankly that we're seeing from employees and advising our employee clients on as well. So that's what we're referring to an illegal layoff. That's where there isn't a right to lay off in the contract. So the contract tip there is when you go to vet your employment contracts, make sure your employment lawyers, and we're happy to help with that, make sure that they have a layoff provision in the contract. We're seeing how critical that is at this point. Communicating with employees while on layoff, I think one of the key things for employers in the workforce, just in terms of employee morale and just generally being a good employer, is being transparent and open with the situation, and in terms of when an employer anticipates they're going to be able to lay them off, what kind of relief they've applied for and what that looks like for them, and just keeping that line of communication open and giving them information as regularly as possible. Are the employers we're working with who've done that, had town hall meetings via Zoom or whatever platform they're using, has gone over, has made this difficult situation a lot more smooth. Constructive dismissal claims I already talked about, and how we get into that territory where there's no provision providing for layoffs. Frustration of contract is another, so constructive dismissal is a position that an employee might take. Frustration is a legal doctrine available to employers, and that happens when an employment contract becomes impossible to perform through no fault of either party. So impossible is the test there, and that's where, again, this is another area we're not sure where the courts are going to land on this. You know, if an employer has an option to provide remote work, for example, will they meet the impossible test? If it's a non-essential business that's been forced to shut down, the impossible test may well be met. So, and if frustration does happen, the employer and the employee are relieved of their obligations, which means the termination entitlements wouldn't flow, except in certain circumstances where there's ESA entitlements to employees. But in this case, the obligations to the employee would not be required. You wouldn't have to pay termination entitlements in that case. So it's a global pandemic. Non-essential businesses are shut down. Maybe there's an argument that there's been frustration of contracts. So we're flagging the issue. It's a topic that could take up an entire webinar, but wanted it to be on your radar as something as a possibility. So let's just take a closer look at the provincial government requirements around layoffs. So under the ESA, as I flagged, that's where we're looking here. The Ontario ESA permits a layoff of 13 weeks in a 20-week period. And in Ontario, this can be extended so that the layoff can be less than 30 weeks in a 52-week period, and that can be a layoff and a recall and then a layoff again. So it's a total of that 35-week number. And at the point where those time frames come to an end, so I'm getting a bit of feedback here. That's a bit better. Apologies. So if we hit these end of the layoff periods, either 13-week or 35 weeks, it triggers a termination, and you go to the employment contract and figure out if there's an enforceable termination provision. Okay, what is this employee owed now on termination? Because in a layoff situation, they're just off work and they're not being paid, and they're probably on CERB or EI, which is CERB at this point. So you figure out what are they owed under their contract. If there's not an enforceable termination provision that guides you, then they'd be entitled to common law reasonable notice. And in order to expand, I think lots of employers are getting close to that 13-week mark. If they laid off around in late March, mid-June is where we're hitting that 13-week period. So we're getting some questions around that. And if there's a need to extend the layoff period, how does an employer do that in Ontario? So these last bullets here are how you get into that longer period of layoff. So by providing substantial payments to the employee, payments to retirement or pension plan or group or employee insurance plans is probably the most common. Employers will continue the benefits coverage in order to bridge them or take them beyond the 13-week period. Supplemental unemployment benefits under the sub-plan, except as Danille will flag again later, if they're on CERB, employers cannot top up through the sub-plan. So and then there's, if an employee is employed elsewhere where they'd be entitled to the supplementary unemployment benefits, that's another way to get past the 13 weeks. If they're recalled within a time approved by the Director of Employment Standards, so that's where you've gotten the director approval of a specific situation, or if they're recalled within the time agreed upon in an agreement. So those are the contexts for going beyond the 13 weeks. As I said, the most common one is an extension of benefits or providing some other kind of payment to the employee to get past the 13 weeks. Okay, recalls and terminations. So when a layoff becomes a termination, as I flagged already, that's where you look at the contract and figure out what entitlements this employee should be getting, and you provide a termination letter. There's no necessarily magic to that, but there is some strategy around that. And what we're doing a lot of is talking to employers about who frankly don't have funds. This is why they're going through this pivot scenario. And sometimes there are some creative solutions that work for employees and employers. Like, for example, you can give working notice and the employer then gets a benefit from the employee during this notice period. Maybe it's for some or all of the notice period. And normally a working notice is not a great scenario, but in a COVID context, employees may prefer to be working. It might make it easier for them to find a job. And if not, it can be a benefit to the employer if the working relationship is still intact to have certain projects finished. So working notice is an option. That's just an example of the kind of creative solutions that can come out of a termination, and taking a look at the full picture sometimes can yield a better solution than just having to pay what's in the contract. You always have to honor your entitlements, but there are ways that can be effective. Business decisions and strategies. Terminating somebody while on layoff, there's not a real difference here. It just means at a certain point in the layoff, I decide, okay, we're not in a position to return this person. So you issue a termination letter and provide the termination entitlements, or figure out what the package needs to look like, and you provide a letter. And that would go, assuming it's done according to the ESA, you'd start at the day of the layoff and provide termination entitlements from that period. In an illegal layoff situation, we're still advising generally, in most cases, that you follow the requirements under the ESA. Recalling employees. So some of the questions we're getting are, who do we recall first? When should we recall them? Can we bring, one or two at a time, or a whole group? So it's really based on what the needs of the business are. And in a unionized context, this would be dictated by the collective agreement, but in the non-unionized context, subject to human rights code considerations, employers can figure out what works best for them. So by human rights considerations, you have to be mindful of the protected grounds and some arguments that employees might make if they're not selected to be recalled sooner or at all. For example, if someone has a disability, is not recalled to a position that there is work for, they may make an argument that they've been excluded for that reason. Or your employees who have child care obligations, you delay them and you bring the ones who don't have child care obligations, and you have to make sure that your decisions are defensible in business decisions. So it might be that the employees couple employees you choose who don't have families, their compensation is lower. So the business decision for bringing them back earlier is that it's less expensive to do that. So really think through and document your legitimate business reasons for selecting who you're recalling and when. And I think this one is over to Danille. Yeah.
Yeah. So I'll provide an update on the government relief options. And these are the programs that I'll be talking about. So the Work Share program, the CEWS, or Canada Emergency Wage Subsidy, that you've likely heard about, workers' compensation, the Canada Emergency Business Account, deferred tax payments, and the Canada Emergency Rental Assistance. So there haven't been updates really on the Work Share program. I just thought I would flag it in the event you haven't heard about it. What it is really is a program to help avoid temporary layoffs or terminations. And it's where both the employer and the employees would agree to take part in this program. And it's where the work sharing unit would reduce its hours of work by at least 10% up to 60%. So everyone's sort of sharing, all the employees are sharing the work that's available. And normally this work share program exists and it's for up to 38 weeks, but because of the COVID-19 situation, it's been extended to 76 weeks. So this is a program that, as an employer, you might want to think about. Most employers are applying or have applied for the CEWS, however. And what this is 75% wage subsidy that eligible employers can apply for. It's retroactive to March 15th, and eligible employers include individuals, taxable corporations, partnerships consisting of eligible employers, nonprofits, and registered charities. And you have to have experienced a drop in revenue of at least 15% in March and 30% for the following months when you're applying. So employers the government, while they are providing this 75% wage subsidy, they do expect employers to top up and to make their best efforts to top up their employees' salaries to the pre-crisis levels, to up to 100% if possible. The deadline, so this program has been extended to August 29th. And here it's a bit interesting how employers need to, if employers are recalling, if employers have laid off some employees and are recalling those employees and want to apply for the wage subsidy for those employees, the way to do that is to pay. So I'll just explain first. To be eligible, an eligible employee is an employee who has not been without pay for more than 14 consecutive days in the eligibility period. So I'll just flip to the next slide here. The eligibility periods are March 15th to April 11th, April 12th to May 9th, and May 10th to June 6th. The program has been extended to August, so we're going to be seeing some additional eligibility periods after June 6th. But when an employer is applying for this, is recalling employees, likely they'll be applying for the wage subsidy for this last period, the May 10th to June 6th. And in order to make that employee eligible, the employer will have to first off pay that employee for that entire pay period, or dating back to May 10th. And if that employee has been laid off and hasn't been working, they would deduct that 14-day period from the pay, and then the employer could apply for the wage subsidy. So that's how that would work. There are penalties. So if employers are found to have artificially reduced their revenues for the purpose of claiming the wage subsidy program, they will be required to repay any amounts received, plus an additional 25% of the total value of the wage subsidy received. So that's just something to think about. So the Canada Emergency Business Account, this is an interesting program. So the government is offering up to $40,000 in interest-free government guaranteed loans. And this is for businesses that had payrolls last year between $20,000 and $1.5 million. The interesting part is that if the loan is repaid, so if as a business owner, you repay this loan by December 31st, 2022, you get 25% forgiven. So you can basically get up to $10,000 in your pocket if you pay the rest of the loan. There are also deferred tax payments, so I'll just go over this briefly. So basically, you can defer paying taxes until after August 31st. This is for payment of income tax amounts owing on or after March 18th and before September of 2020. And there will be no interest or penalties on these amounts during that period of time. And then there's this Canada Emergency Commercial Rental Assistance. So the government has just recently released details on this program. Basically, this is intended to be for businesses that have had to close. So you have to have experienced a reduction in business of at least 70% to apply as a tenant. And the owner or the landlord has to agree. So the way it works is the government provides a 50% loan to the owner or the landlord. The landlord contributes at least 25% of the rent, and the tenant would contribute 25% at most of the rent. There has to be an agreement in writing between the landlord and the tenant, and the agreement has to say that there will be a moratorium on eviction for the period of April, May, and June. So this is to be applied for April, May, and June. So it's to be applied retroactively. So you might be wondering, why would landlords agree to do this? Well, getting up to 75% of your rent could be better than nothing. And at the end, when it's over, the loan will be forgiven. So basically, the government is saying, if as a landlord you abide by all of the terms and conditions, which includes not recovering the forgiven rent amounts from the tenants, then they're forgiving the loan. So that's how that works. It's an interesting program. Applications have not opened yet, so they will be open at the end of May. So shortly. And then we're just going to touch on support for employees that exist. There's the infectious disease emergency leave that you've probably heard about, and the CERB, or Canada Emergency Response Benefit, that you've likely heard about.
Okay, so I'll just run through the infectious disease emergency leave, sometimes known as the COVID leave. This is an unpaid leave for employees, and it's job protected leave from termination and layoff. To be eligible, employees need to show they can't attend work because of any of these 5 reasons here. So because they themselves are sick, because they're in quarantine, including self-quarantine, because schools are closed and they have to take care of their kids. And we all will know that as of yesterday, schools will be closed for the rest of the year. And as much as I love my children, I'm still processing that decision or that announcement. If employees are stuck in another country due to travel restrictions, or if they need to care for someone who's sick. So those are the eligibility requirements for the COVID leave. And there's no requirement to provide a doctor's note to substantiate the request for the leave. Okay, now I'm going to talk about CERB. So this is a benefit of $500 a week for 16 weeks. It's available to workers. And the requirements are set out here in the bullets. They have to live in Canada and they have to be 15 years of age minimum. They must have stopped working because of COVID-related reasons, or be eligible for EI regular or EI sick benefits, or have exhausted their EI regular benefits or EI fishing benefits between December 29th, 2019 and October 3rd, 2020. They have had to have had employment or self-employment income of at least $5,000 in 2019 or in the 12 months prior to the date that they apply for CERB. They are not allowed to have quit their job, and they can earn up to $1,000 in employment or self-employment income for 14 or more consecutive days within the 4-week benefit period of their claim. That's the maximum. It's no more than $1,000 in employment or self-employment income for 14 or more consecutive days within the 4-week benefit period of their claim. Many of you will be quite familiar with CERB by this point. So it allows, this is Danielle, you're going to talk about the subplan update, right? This is breaking news as of last week.
Yeah, right. Breaking news. A lot of employers have asked about the subplan, which is the supplementary unemployment benefit plan. So normally if an employee is on EI, an employer can choose to enter into this subplan and provide, it's basically an EI top-up plan. The government's confirmed that you cannot cannot apply for this program for the CERB. So employers can top up to $1,000 per month. So they can, like, that $1,000 can be employment or self-employment income. So if as an employer you want to bring in your employees to work for up to $1,000 per month, you can. Or if you want to just provide them $1,000 per month to top them up, you can. But that's the only thing you can do. You can't top up more than that, and you can't apply for the sub plan. All right, pivoting your workforce.
So I'm going to talk a little bit about reduction options as part of this pivot. What's available to employers if they're really feeling this crunch and need to go to the drawing board and figure out a plan. So we're seeing employers reduce hours and corresponding pay of their employees, or just simply reducing their pay with the same amount of work. And the way the way that we've been recommending that this happen is they provide a letter. Again, full transparency. The messaging is very important, explaining why this is a necessary move by the employer in order to survive, and asking them to agree to that reduction. And when in several cases with the right messaging and the transparency, employees have agreed to these kinds of reductions and have signed back agreements, which reduces the risk, or frankly eliminates the risk of constructive dismissal claims in relation to those reductions. Reducing or eliminating benefits is another option, and many employment contracts contain employer-friendly discretionary language that lets employers reduce or eliminate benefits coverage. So that's worth looking at if that would be helpful. Cost reduction. A combination of layoffs or terminations is another thing we're seeing. And I've talked about those already, and the letters and tools and guides are in our Pivot DIY offering to help with those kinds of implementing layoffs and terminations. Another issue that we've advised on more recently is independent contractor roles and introducing those into the workplace. That would need to be done if you'd have to characterize your workers appropriately, and the way to do that appropriately would be if you legitimately have roles that involved where this person would be a freelancer, and you can give them the independence, and they are going to be working somewhere else, and it works for the employer. There's a project base, there's a project that needs to be done, but there isn't enough work for full-time employment. So you'd have to really look at how you're characterizing it and how you're documenting, papering that kind of relationship. But that's something that some employers are looking at. And Danielle's going to talk about some reopening.
So as more and more businesses are reopening right now, there is a lot of talk around health and safety concerns. A lot of employees are concerned and are worried and are wondering how their employers are going to be making the workplace safe, and what they can do if they feel that they don't feel safe in their workplace. So there's the right to refuse to work, and this is a formal process under the Occupational Health and Safety Act. The standard is, or the bar is pretty high, so it actually has to be a danger. There has to be a danger and not simply a risk. And what happens if someone is refusing to work under the Occupational Health and Safety Act? The way it works is that the worker would report that to the employer, say they don't feel safe. The employer would then do an investigation, and then along with a worker safety representative, and then the issue would either be resolved, or if it's not resolved and the employee says, okay, you've investigated and you've done some minor changes, or you find that there's no risk here, or there's no danger, I still don't feel safe to work, I'm not working. Then at that point, it gets into the second stage, where the employer would contact the Ministry of Labor, and a ministry inspector would come and inspect the workplace. The inspector would then do an investigation and make a decision in writing, and if changes are required, it will be ordered. If the inspector finds that the workplace is safe, then at that point the employer can require that the employee come back to work, or the employee can make a decision to leave or not. One thing to keep in mind is in this first stage, so when an employee is saying they don't feel safe, and when the employer is doing the investigation, even though the employee is not working during that period of time, however long it lasts, the ministry's position is that the employee should be paid for that time. So that's something to keep in mind. There's also some talk or people are wondering about risks of liability as the employer. That is a live issue, and if an employee were to get COVID-19 while they were working, and if the employer and employee has the worker or if the employer pays into their workers' compensation, the WSIB, the WSIB will cover the employee during the period of time that they need to take off and whatever expenses, related expenses to that. Otherwise, we're recommending that employers make a plan. So, and that could really help if they are, if later on, if they don't have workers' compensation and or an employee is saying that, they got COVID or there's some liability issues. If the employer has a clear plan and implemented this plan, then they have that to fall back on. So first, as businesses, if you're an employer and you're open or you're planning on reopening soon, you're going to want to determine who will design and implement the plan. You're going to want to assess the workplace, develop a return to work plan for employees coming back to work, how this plan will be implemented, and you'll want to review, there are quite a few government and public health guidance websites. So if you can just quickly, there's actually one down below here with the link, and these slides will be shared, or they're shared with you in the handouts. But there's a sector-specific safety guide, which can help employers on how to keep their workplace safe. And you want to monitor the compliance of the plan that you've implemented, and then just respond to the issues as they arise, and then adapt the plan as necessary. So if there are liability issues in the future, at least you have this to fall back on. And I just wanted to note actually this first point, that the government's saying that there will be stiff penalties up to $10,000 for employees who cannot open yet, but that are opening. So employers, really want to stick to the guidelines and not open it until you really can.
Danille, I just wanted to jump in. And one thing I forgot to mention, the reduction options, when we're talking about reducing hours, reducing pay, making some changes that could be in constructive dismissal territory. One thing we looked at recently is some case law that is frankly somewhat surprising, but it allows, the courts allowed employers to make changes that would be considered unilateral fundamental changes to terms of employment. And so it's worth looking at your employment agreements to see if you have those kinds of change provisions that allow these changes that would help defend against constructive dismissal claims. And again, drafting tip, when you go to have your contracts vetted, make sure you have the layoff provision and take a look at having this kind of employer-friendly discretionary language that permits these kind of changes, similar to the way we see with benefits coverage, as I noted earlier.
Yeah, good point. We have a couple questions.
Yeah, I was actually looking at this one while you were speaking, Danille, so I can jump in here. We have a viewer asked about whether an acute mental health issue resulting from mandatory isolation would make them eligible for the COVID leave. And I think, again, this is all new territory, but I think, the leave workers are entitled when they have stopped working because of reasons related to COVID-19. So I think there's going to be a lot of leniency around what qualifies, what makes an employee eligible. And I think I would say that they could make a good case for being eligible for the leave. You'd need to understand and ask questions, be mindful of privacy issues, but work with the employee to find out what the issue is. And then it would trigger an accommodation process based on the mental health issues. And then you'd be in that stream of having to, be mindful of communicating with the employee and making sure you accommodate them to accommodate their disability and get a plan in place. But I would say that they would likely be entitled to the COVID leave.
Yeah, I agree. It's, if you look at the eligibility criteria here, like if they are sick, and that it's pretty vague, and just the fact that the employee doesn't have to provide a doctor's note. I mean,
Good point. Yeah.
It's there are a lot of things that could fall into this criteria.
Another question: if an employee is opted to self-isolate but has not requested leave or has not identified the reason why, what steps should the employer take before the action is considered job abandonment? So again, I think communication and first of all, just speaking to the employee and finding out what the reason is, and if employer needs to be acting reasonably. But if they, if there's not a danger, then there's, and they've canvassed the reasons and find out what's going on with the employee without be mindful of their privacy and health related information. If you've done their due diligence and acted reasonably, you're getting close to a job abandonment argument at that point. What do you think, Danille? Yeah,
it's interesting. I think people's mental health is getting affected by this pandemic, and puts employees and employers in difficult situations. But if an employee is requesting to self-isolate, not identifying the reason why, I mean, it's is that a sort of a disability issue? As an employer, you do have to inquire. And I mean, yeah, you could take steps depending on how it's lasting. You could make the argument of job abandonment potentially. Without knowing more details, it's kind of hard to say. But yeah, no, I agree with what you said, Marnie. And yeah, it's a tough one. I mean, there is the unpaid leave, right? So if they're just on the unpaid leave, you might want to wait it out for a bit. You're not necessarily having to pay them. Otherwise, yeah, if you absolutely need them to be working, that's more of a difficult position to be in as an employer. And at that point, it could be, job abandonment or termination. If you don't want to pay termination packages, then I mean, it's a bit of an aggressive position to take, I think. What do you think, Marnie?
Yeah, I think you start by gathering the facts and finding out what's going on with them and making sure that you're demonstrating that you're acting reasonably, you're being sensitive to the situation, and then you make a plan from there. It really does depend. It's the lawyerly answer, but it does depend. These ones involving health issues, mental health issues, and this really difficult situation everyone's been in for a while, it does require some sensitive treatment by employers for sure. I mean, they should always be acting sensitively towards employees, but especially now. There was another question about an older employee with previous health issues had requested not to work at the beginning of the COVID pandemic at the suggestion of a doctor. He now wants to come back. Can we let him return? And I think, again, it's communication, and there's no reason not to have the employee return if he's asymptomatic, and then absolutely there's,
Yeah, I agree. And if you have a plan in place, I mean, there's social distancing at the workplace, and you can ensure that that employee is going to be safe, or that there's no danger, then absolutely. Okay, this next one. You mentioned that for extending the layoff beyond 13 weeks, we would need to provide some other payments. We have staff on layoff who do not have a benefits package. What other payment could we offer? Yeah, I mean, the ESA just says substantial payments. So, I mean, that could be a few different things. It's quite vague, actually. I would recommend calling the ESA hotline. and getting a bit more detail on that. What are substantial payments and what would qualify and what would not qualify. But there could be that, and other than substantial payments, I'm not sure if anything else would necessarily.
Maybe additional vacation time, Danielle, paid vacation time, something of value. Right. And if it's something that's borderline, you could get the employee's agreement and say, look, this could work for us. We have a slow period in the beginning of the summer, or would this work for you? And that way they're buying in and they're agreeing to it. But I think I like that suggestion, calling, because in the COVID context, we're not sure what again, we're likely to see more leniency by Ministry of Labor and Courts. So what does that mean? So calling that ESA hotline is a great idea, and find out what they're, even though they don't give legal advice, they might give some suggestions on what substantial payments might be. And then if you don't get the answer you want, there's also the, well, out of necessity, you might just have to do what you can and accept the risk and make that business decision.
Exactly.
Even though your substantial payment might not be substantial enough, some employers are just having to roll the dice and go ahead.
I think that's it for questions.
Well, thank you very much, everyone, for joining us today. Do you have anything else to add? Other than that, the webinar will be up on our YouTube channel, and the materials are available for downloading. And yeah, that's it for today. Thank you very much, and best of luck with your pivoting of your workforces. Thanks for joining us.
Thanks.